can issue maintenance orders along with the protection and occupation orders. Now, these orders can be made, by the court of their own doing, even if you don't ask, but it can also be made on the application of the prescribed person or whoever is just bringing the matter to the court. So, for instance, the court may order that even though a father is being excluded from the household because of his abuse of the mother and the child, that he maintains the child, that him pay the pitney school fee and send the pitney go school. So that is something that the Domestic Violence Act, the legislators, they considered, and that is available under the act. A reason many persons don't go to court is, so what am I going to do now? Pitney have to go to school, I have to go to work, we have to eat. What is going to happen when I bring this matter to court? And there is an avenue through the court granting maintenance orders, you asking for maintenance orders. Now, what is important to note is that the maintenance order does not exceed the term of the protection order or the occupation order. What this means is, if you didn't have a maintenance order from the court before, and the court says there's an interim order in place, who remembers what an interim order is? In the meantime order. There's an in the meantime order in place for 2 months before the perpetrator has to go to court. And the court orders maintenance. The maintenance order also has to last 2 months. Because what will happen is the court has to consider the substantive matter, the entire matter, before making those full and final orders, whether it is the protection order, the occupation order, or the maintenance order. Now, you have ancillary orders under the Act. And I chuckle a little bit. My analogy is, if me get the house, me must get the furniture. If me can't stay in the house, me must can use the bed, the iron, the fridge. But that is not so. It is an order that the court has to make. So in asking the court to make an occupation order, you're also going to ask the court to make these orders. And when I say you, I mean the very people in this room. I don't mean attorneys. A lot of time people go to court on their own without an attorney asking for a protection order, an occupation order. And that is why it's important that they and you are aware of these ancillary orders. One ancillary order, particularly where there's an occupation order in place, is asking the court that they allow, permit, order that you are able to use the furniture, the household appliances, household effects in the residence in which the occupation order relates. So you can't come take up the bed. That's what I mean. Ancillary orders. Again, such an order may be made at the same time that an occupation order is made or after the occupation order, and it is valid for 3 months. Breach. What is the consequence of a breach under the Domestic Violence Act, or a breach of an order made in pursuance of the Domestic Violence Act? So, a fine of up to $1 million, imprisonment of up to 12 months, or both. Now, imprisonment of up to 12 months. Is that a sufficient deterrent? Is that enough? And we'll get into possible recommendations for reform. So just want to pause for cause. So what I've already presented is an overview of the Act. I've already explained what it covers, the possible orders, maintenance, protection, occupation. And we're law students here, and We are grateful for the protection that is already there, but as law students and even as people who aren't exposed to the law, we're critical of what is in place to protect us, and that is what we're about to do here. We're about to talk about some recommendations for reform. And before I even go into it, I would like to recognize Miss McLean once more, who Miss Birthright identified as as a person who's passionate about the Domestic Violence Act. But she's a little bit more than passionate. She's knowledgeable, very insightful. And I just want to highlight that while, the recommendations for reform is not anything new, a lot of my knowledge about it, a lot of Group K's knowledge about it came from her guidance and her insight, and we're grateful for her as students who are responsible for interrogating the law, as we're the ones who will inevitably have to make these changes. So, recommendations for reform. We believe, we're of the view that there needs to be an expanded definition of domestic violence to include not just physical violence. It's not enough, or it shouldn't just be limited to you being hit or grabbed. It should include psychological or emotional violence, economic abuse. A lot of times, the way perpetrators control survivors is finances. You have nowhere to go. They hold on to your card, your bank account, they control your money, your paycheck goes to them, and that sort of financial abuse is what, I guess, continues the cycle. And so expanding the definition of domestic violence gives greater protection, because when you go to the court and you say, say, him collect my paycheck and him spend it and him do this and him do that, then the court can say, yes, this is a situation that I can, this is a situation where I can afford you or give you protection. Technology facilitated violence. So, bullying on social media, threatening to release risque pictures, threatening to post something that's going to make you lose your job. Could be anything. So technology facilitated violence, which is something that is a very live issue in our society today, but the Domestic Violence Act does not cover it. Property damage. So just including more, not just a wider scope, but specific definitions, specific examples in the Act will afford more protection. So yes, clear categorization to aid victims, law enforcement, and courts. Because as law enforcement, as victims who are going to the courts or going to law enforcement, they're guided by the Act. And if the Act doesn't afford the protection, then they can't protect you. If the Act says that, if the Act doesn't specifically say that it is illegal or that it falls within the definition of domestic violence to threaten to or to release certain photos of you, then the court cannot order a protection order. The court cannot give an occupation order, and the court can't give those ancillary orders. Again, broaden the scope of prescribed persons to protect all intimate partners. Now, let's zoom in on all intimate partners for a brief moment. So the Act protects spouses, and in the Jamaican context, to be a spouse, you have to live as man and wife for 5 years. A single man, single woman living as man and wife for 5 years. And there are certain criteria. There's a time limit of minimum 5 years. But what if we've only been together for 3 months? Or what if we just started dating? I just met you and you are the perpetrator is carrying out conduct which falls under the Act. But because they're not considered a perpetrator under the act, you are not able to go to the court to get this protection. So protect all intimate partners regardless of marital status, regardless of cohabitation or relationship duration. Include formal relationships and dating scenarios aligning with models like St. Kitts and Nevis. And then more specific court orders, including firearm seizures, professional counseling, structured child access, and monetary compensation. And then also just, reform and modification of the application or the provision that deals with applications by third parties by removing the requirement that the court's permission is granted to third parties to apply on behalf of victims and allow exceptions for vulnerable individuals unable to consent. So if you see something happening, just allow you to apply it and the court will consider it instead of you first having to say, give me permission to apply. Emergency applications permit applications outside of the regular court hours and mandate hearings within 24 to 48 hours of filing the application. Mandatory counseling, that is another recommended area of reform. Reforming or amending the duration of the order. So establish maximum periods for interim orders and final protection orders with the option of extensions for victims. Specify, so the act does talk about things that the court has to consider, but it doesn't specify what the court has to consider or should consider. Specify factors like violence, the child's welfare, financial circumstances, and so on. The responsibilities. So again, it just shows the areas of improvement or potential improvement of the act. So we suggest that the act should mandate responses to all domestic violence reports, regardless of severity, requiring completion of a report for accountability. Then also, as it relates to enforcement, to provide that it should be automatic that these protection orders are sent to the local police station to facilitate enforcement, because they're the ones you're going to call and they don't know about the situation because they don't have hold of these protection orders. Now, just to wrap up, the Domestic Violence Act in Jamaica plays a critical role in protecting vulnerable individuals from abuse and promoting safety within families and intimate relationships. However, evolving societal dynamics and emerging forms of abuse necessitate a comprehensive review and reform of the Act. Reforming the Domestic Violence Act is an essential step towards creating a more robust, inclusive framework that effectively safeguards survivors of abuse. By expanding definitions, broadening the scope of protection, specifying court orders, and reinforcing law enforcement responsibilities, Jamaica can ensure that no survivor is left without recourse. And we've already gone through why reform is necessary. Thank you so much, ladies and gentlemen.
Thank you so much, Sudan. That was in-depth and informative. We are going to transition quickly into the panel discussion because I know we have some challenges with time. We're expected, as you know, to start at 10, but we're just going to transition. If you don't mind, panelists, let me welcome the panelists again. So with us today, grateful to have their presence, Her Honor, Mrs. Georgette Davis, Parish Court Judge. Thank you. Dr. Olivia Rose, Applied Sports Psychologist. Ms. Joni James from the Bureau of Gender. She's a social worker. I'm just going back to the front. All right. Let me ask the first question to you, Dr. Olivia Rose. Who, based on your experience, who are the persons generally affected by domestic violence?
Good morning, everyone. I am Olivia Rose. I'm happy to be here. And thank you so much for that question, Miss Birthright. And the answer is simple it's everybody, all race, creed, socioeconomic status, you name it. But of course, there is a higher percentage of women and children who are victims and, as your previous presenter said, survivors of domestic violence.
Thank you so much. Miss Joni James, as a stakeholder, what is the role of the Bureau of Gender Affairs?
Good morning, everyone. I am Miss Joni James. I'm a social worker at the Bureau of Gender Affairs. So the Bureau of Gender Affairs, we are one arm of the gender division in the Ministry of Culture, Gender, Entertainment and Sport. The Bureau offers counseling services for persons who are victims of domestic violence. So we have a male helpline unit as well as we have a female helpline unit, and it's 24 hours where persons can reach out and get assistance. The Bureau started in 1972 as a special committee to integrate women into national development. However, on March 21st, we were rebranded through our minister and we're now the Bureau of Gender Affairs. So when we started, we advocate for the rights of women. However, now we have a male empowerment unit, a space where men can be empowered. So persons, male victims, because they are male victims as well, a lot of the times the male victims in our society are unable to report it because of social norms. But a lot of male victims do come to the DV centers, and I see my colleague from the JSF as well that is here. So there are a lot of male victims that needs assistance, and the Bureau facilitate for both the male and the female.
Thank you for that. And we want to welcome the police here. This DSP Jacqueline Dillon always works her magic. Thank you so much for being present. Yes, we're going to ask the tough question of the parish court judge. So we heard a lot about ex parte orders. I'm going to start there. And any background you want to give us as well, because I know you have a wealth of experience in this field, this area of the law. So tell us about ex parte protection orders. How does the court balance the ex parte protection orders with ensuring due process with the rights of the respondents?
All right, so the short answer to that is interim. So as was mentioned in the presentation earlier, once a person comes, an affected person, and the assessment is made that the situation is one of urgency, then the matter is put before the court right away. Of course, we cannot go ahead and make anything final until the other person has had an opportunity to respond to allegations, because that is what they are in that setting at that time. So we make the order in the interim, and then instructions are given for the interim order to be served on the person. They are normally told that they are not supposed to serve it, to get a police to serve it, and then a date is fixed for the inter partes hearing. So that is what we do. When they come for the inter partes hearing, then the respondent who should have been served with the application ahead of time is normally asked, have you read the affidavit, which normally accompanies the application? And I normally ask, do you agree with what is in the affidavit? Is everything that this person has said true about you? And they get they get an opportunity to state their case. So that is how we balance the rights of the respondent vis-a-vis the rights of the applicant.
Thank you so much. I am going to stick with you and then come back because we learned a lot today from Sudan and the presentation that was ably prepared by our team. But we everybody knows what an ex parte order is now, right? Yes? Yes? But I'm sure you want some more information on protection orders and occupation orders. So in your experience, What factors do you consider when deciding between these different types of orders that the courts can give?
All right, well, before I get to even invoking any consideration, you have to apply, because I cannot grant something that has not been applied for. So you have to apply. There have been applications. There are some that say once a protection order is applied for, then as a matter of course, an occupation order should also be applied for, but that's not always the case. Sometimes they just come and apply for the protection order. That's all they want, because not everybody is living in the same space. Some people are just in visiting relationships. So some people just come and ask for the bare occupation order. But as it relates to factors that are considered, section, I think it's 3, even the amended section, which has amended the Principal Act 3, I think section 3, tells you the things that you take into consideration. So of course you are looking first of all, is this person entitled to apply? Because if you have no locus, then I can't hear you. So if once you are allowed to apply, then we move on to the other factors. So what is it that you are applying for? Depending on the conduct, does it qualify? Does it fall in any of the subcategories that I am looking for in terms of the conduct that I will prohibit if the order is granted? And once we go through that checklist, I'm also looking for a pattern of abuse. I'm looking for a pattern. No. This is a kind of ticklish thing, because some people will say, am I supposed to wait for him to beat me up 2 times or 3 times before I come and say, why is it not good enough to come the first time? And I understand, having dealt with this particular piece of legislation at its different levels. I was a clerk and I had to write up the orders, and then I went into the ministry, and the amendments that we have now were drafted by me before I transitioned to where I am now. So I have had the experience of this particular piece of legislation at the different levels. And I understand the thinking, but at the same time, you want more than a one-time thing. Because there are other pieces of legislation. I noticed that Sudan, she made mention of a lot of recommendations there, and I noted them because depending on what they are, the domestic violence legislation might not be the suitable legislation for you. If somebody has posted pictures online or threatened to release or so, there's the Cyber Crimes Act and there's malicious communication. If they have threatened you, you go and you make your complaint and you bring them under the either town and communities or the other one that deals with threat. So there are different pieces of legislation that you can use. But back to the question you asked me. So I'm looking, do you qualify? What's the conduct that you're doing? Does it fall within the prescriptors? And once I do that, then I will make the order. As it relates to the occupation order, I'm asking, whose property is this? Whose house is this? Whose dwelling is this? Because that will determine, as Sudan said, should someone else also be here in relation to that property? If it is owned by the person who is asking, then that's a different conversation. If it is a case, and I heard some of the ladies mumbling when the presentation was going on, that they live in the space and the respondent is the owner, then we might have to have a kind of conversation as to where you can maybe go until such time, until we have a hearing to determine how we treat with that. But those are some of the things.
Very in-depth. Thank you so much for that. And it leads me to my next question, Dr. Rose. Why is there such a culture of silence? And what can we do to address this issue so that persons like the ladies here are more willing to report and to go before the courts?
Okay, so that's a difficult one, but being a Jamaican and understanding Caribbean culture, we operate in a space where we do almost everything to avoid shame and embarrassment. And one of the things about domestic violence is that usually the victims, the survivors, usually feel an immense amount of shame and guilt. And because of these emotions, they're more likely to disclose if they were cheated on or if you did get bun, because I'm sure you all understand what that means, especially if it's without cheese. But you're not going to feel so liberated most times. Usually, they are not to talk about being physically or emotionally abused, especially the physical abuse part of it. And then there is also the notion of fear of how the perpetrator is going to retaliate, and also depending on who it is and where it occurred, the fear of even being believed. So with all of those combined with an umbrella of a culture of avoiding shame and embarrassment, that's why there is silence. But it is discussions and forums like these that help to break the silence, and that's why this is definitely encouraged, and we should have more dialogue in spaces like this.
Very good. Thank you so much for that support. So, Miss James, tell us, what support does the Bureau offer to women who feel like what Dr. Rose just described? They're ashamed of their situation. What support does the Bureau of Gender Affairs offer?
I want to add as well, the support do we offer for male and female, because the Bureau is
Okay.
all about
Yes.
advancing men and women.
Sure.
So at the Bureau of Gender Affairs, I will walk you through the process that a client comes in. First, when it comes down to domestic violence, the first arm of response is always the JCF. So the Domestic Violence IQ Center, and there are 10 across Jamaica where persons will go to report. We're located in Kingston, and the nearest one would be at Matilda's Corner, and there's also one in Constant Spring. Once the victim reach out to the officer at Matilda's Corner, the next process is to either call the helpline numbers or they can come to the Bureau. Once they come to the Bureau offers a national shelters for the female victim and her children. In the event that the victim needs safe housing, the national shelter is that option. So the victim comes to the Bureau, there is two arms in which she would go under. So there's the GBV helpline numbers. You hearing me clearly? Okay, there's a GBV helpline unit where the victim will reach out to the social worker, will do the assessment and determine if the victim is fit for the national shelter. Why I say fit, if the victim has ailments that they need a medical facility or they need to be hospitalized, then the national shelter cannot facilitate that. But in any other event, once the assessment is done, then they're granted access to the national shelter. On the other arm, not everybody needs assistance to the national shelter. So victim may need assistance with first level intervention. So the Bureau offers free counseling services for the victim. So the victim is able to access the free counseling services. They say that they need assistance with medical bills. They say that they need a little rental assistance, a little grocery packages. An assessment is done before these services available to the victim. Let's say that the victim also needs assistance, finding employment. The Bureau would also link them to other ministries, Ministry of Labor and other agencies in best to assist the victim. So these are in general the services that is offered for persons who are victims of gender-based violence. It's the same time for which one of them? Right, living assistant. So the social worker has to do the investigation. So we have to carry the investigation to do the assessment. Because several times persons can come and say they need assistance, and when you turn it out, is you're going to pay for the perpetrator and the victim, and and that is just going to lead into other things. So the social worker, the victim comes today, the social worker will go out and do the assessment in the community, and sometimes the police officers as well are aware of the situation and can verify that. And once everything is up and up, then the issue a lot of the times with the turnaround is the payment process may take a while, because getting the info, a lot of the times persons don't know that the victim don't have a TRN. So a banking, yes, so those issues and ID can pose a problem, because then it's for the Bureau now to try to get all of these documents when it comes on to that. So it's all depending on that, but it's not a long turnaround time. And for persons will ask how long does person stay in the national shelter. The turnaround time is based on the individual. In general, it's 6 to 8 weeks, but some persons can, expand to 2 years depending on the situation. Until the victim is also ready to go back into the work world, then that's when the person, will able to leave the shelter. And at the shelter, same assistance is provided for them. So they offer persons who want to get to start their own business, or link them to other agencies, so when they're out, they're able to take care of themselves as well. So, and the same, yeah.
So you sounds
A
like you
mouthful.
need to be around at the end, so we have further discussions there. But thank you for that answer. Her Honor, can you tell us? We spoke to it in the presentation, the 2023 amendments. It increased the penalties from 10,000 to 1 million, and imprisonment from 6 months to 1 year for breaching protection orders. What impact do you anticipate these increased penalties will have on compliance and deterrence?
Well, I can't use the word anticipate anymore because the 2023 amendment has been in force for a little while. So I can tell you the impact. Well, I can go past and maybe present. At the time when we were putting these amendments together, the impact I anticipated it would have, definitely that it would deter people from breaching the orders. As I told you not too long ago, that I was a clerk in my former life. And I had seen where perpetrators would come to court, more than most, the men. And when they hear that it's 10,000 or 6 months, child, pay the 10,000. That's enough money for me. Pay the 10,000 and they move along. Know that the penalty, and that was actually one of the criticisms levied at the Domestic Violence Act, why the penalty was moved, because it was felt that the perpetrators were not taking it seriously. So now that the penalty has increased, I have had one situation come before me since I have been on the bench where the lady actually made a report that the order was breached. And I'm going to come back to that and why that is important. And I looked on him and I knew he could not afford $1 million. And so I said to him, well, the legislation says $1 million or 6 months imprisonment or both. So take your pick. What do you want to do? He says he will pay. I said, you're going to pay the $1 million? No, he will pay some money, but he can't afford the $1 million. I said, okay, how much can you pay? He wanted $10,000. I said, that price stop giveaway, sir. You have to give me another price. What can you pay? So of course he couldn't say anything. I used my discretion. I fined him $50,000. It took him a while to drum up the money, but that was not my business. So it made him think twice, because he was always troubling the lady. He was always harassing the lady, but she actually made a report that he breached the order. And that is something that I have always seen. So you grant the protection order, and that is great. It serves a purpose. It's supposed to deter certain actions. But if the person goes contrary to the order, the protection order, and the applicant does not report the breach, then there is nothing that the court can do. So she actually reported the breach, and there's nothing that the police can do either if the breach is not reported. So that is, there is, I'm not seeing a proliferation now of breaches of the protection order because the fine is so high. So that is good. It's making them think twice about their behavior.
Well, true, or we need to remove that culture of silence as well. So ladies and gentlemen watching, the culture of silence is something that we need to get rid of. I'm going to start to talk, incorporate sustainable development. And so I'm going to ask Dr. Rose, how can persons affected recover from the scourge of domestic violence?
Okay, recovery. Recovery. Recovery is a deeply personal journey. It is not instantaneous and it takes time and it takes a supportive community network, which I believe is also represented here. And so it is about also educating persons so that they know where and who and how to tap into the resources. It's also about breaking some of the myths and trying to understand what really happens to the victims until they become survivors, because initially they are victims. And that is why the journey is a personal one that varies from individual to individuals. For some people, depending on how strong their support system is, which is why you should always try to be in community groups and do not feel ashamed to talk about what's going on, because it is through breaking the silence that we are able to also go through the journey with you and to help you to recover. And of course, therapy through professional counseling is highly recommended. And of course, through family and supportive friends, not people who will tell you to go back into a situation because it's financially viable for them, but people who really have your well being at heart. So it's a really personal journey that varies from individual to individual once you tap into your support network.
All right. And I'm happy to have Scotiabank here. Just a little plug, or one of our main sponsors. Miss James, how does economic dependence, though, impact women's decision to report, to leave, to get help?
Contrary to what most persons may believe, economic dependence is not at the forefront, but low self-esteem and how we value ourselves is at the forefront. Because a lot of the time, when you think about DV does not have any face. It can impact me, it can impact you, it impact everybody. Sometimes the females are at a state where they are able to manage financially, but they stay in this relationship. Why? A lot of the times when we think about parenting, our parents didn't give us that tool to value ourselves. So we think about the children more than we think about the whole situation. We think about the man, we think about how it will look, the society, the church will think and so forth. And we don't think that the impact of us staying in the relationship has a greater impact on the child in the relationship, because guess what? The children in the marriage will definitely, they are victims by seeing it, hearing it, and they will either become a perpetrator tomorrow or they will become an abuser. And that's why the cycle continues when you think about that. While it does play some factors with persons, but it's not the major factor. And I always say to individuals, and we do a lot of training and workshop and to mothers as well, teach our daughters, teach our sons how to be independent. It doesn't matter how small it is, but it's something that you can, give assistance when you think about it in that sense. And, financial abuse is always a factor when you think about domestic violence, and it's a culture now where Jamaicans, we think it's not an issue. We see the physical abuse, but we don't see the financial abuse. And I always say to persons, once you're in the household and your partner is not contributing, then that is a red flag, and that is considered as financial abuse, because you're impacting the other partner as well as the children in the marriage and the relationship.
Oh, thank you for that. Thank you for that. Well deserved. And you mentioned children, so I want to ask Her Honor about the amended act. It's more explicit now in that it allows the children's advocate to make applications where conduct is threatened against a child. How does this improve protection for vulnerable children? How has it?
Well, it's really another layer of protection for the children, because before, parents, guardians, social workers under the old Section 4 were allowed to make applications on behalf of the children. I must confess that I have not seen I have not seen, this is my experience, any social worker making an application on behalf of the child, and I found it very strange. And now that we have the children's advocate, that is great. It's another layer of protection because we know the children's advocate, they are the primary arm responsible for the rights of the child. So that is very important. And so if the parent is neglectful in his or her duty, the guardian doesn't want to do it for whatever reason, no one else wants to make the application on behalf of the child, then the Office of the Children's Advocate can step in without permission from either of those and say, this child needs to be protected against, and I am going to defend the rights of this child, and I'm going to apply. So it's an objective test that doesn't rely on anything from any supervisory parental figure, which is very good.
All right, thank you so much. I'm going to stick with you because we're going to be wrapping up shortly. When the court recommends counseling under Section 18, what mechanisms exist to monitor compliance and effectiveness?
Well, my experience has been at the varying levels. When counseling is recommended by the court, the matter is not fully dispensed with. So there's an interim order that is in place, because if you send them through the door, if you give a final order, how are you going to follow up if the counseling is actually going on and the progress that may or may not be happening in the counseling? So it's normally under an interim order. Sufficient time is given to allow for the counseling to work, or in hopes that it will work. And the referral is normally made to the probation services, and they will provide counseling from that department. They normally put together a report, it's requested, and they bring it to the court on the next date slated for the matter, so the court can understand what has been happening in the counseling. For some couples, I have seen it work. For others, it doesn't work. And so we have to go on to either a hearing if it is necessary, or we see what we can do there. But that is how we monitor. And my experience also has been that there are some couples who come and apply, or an applicant comes and applies for a protection order, but it's not really a protection order they want, Some of them still want to be in the relationship, Miss Joni. Some of them still want to be in the relationship, and they're just having a hard time right now, and they want to remain with the man or the woman, but him and her cheating on them, and they having all sorts of arguments, and they feel if they get a little counseling, they can return to the days where the relationship was good. Some of them will tell you that is what they want, but they have made the application. So because you have to honor the request of the parties and their wishes. So you send them to counseling, see if it works. As I said, it works for some, it doesn't work for others. But that is how we monitor.
Okay. Through the courts. Thank you so much for that. Dr. Rose, last question for you, and then I'm going to ask everybody to give their closing remarks in conclusion. But question for you, and then question for Ms. James, and then we wrap up. What recommendations do you have to help the renewal of persons affected to start over, to start afresh, if that is what they desire?
Thank you for that last part about if that's what they desire, because that's usually the challenge. But once you desire to make a new start, it's not going to be void of some unfortunate and painful memories. So again, counseling and tapping into your network and your community, I can't overemphasize this, is going to be really crucial. And showing yourself a lot of self-compassion and self-care and all of those wonderful revitalizing and rejuvenating words and treatment. And in fact, I brought 4 self-care 30-day challenge journals that can be given to, I guess, the person who came first, and you can decide who else can get the other 3. And it gives you some tips as to some things that you can do if you decide to start afresh and to experience life in a different way and to alter the whole course of an ending that could have really ended your life.
Yes, that's so true. And then finally, Ms. James. Are there any specific programs that have been most effective in helping survivors? I had here to achieve economic independence, but I know you put a spin on it. So let us have a holistic independence.
So based on the programs I told you about that the Bureau offers, apart from the psychosocial support that we offers, we also do a lot of public education when you think about that, as well as training. So we have a financial literacy workshop that we do in the community, and as well as it is offered to at the National Shelter, where the victims will get, how what is saving. A lot of Jamaicans don't know how to save, how to make a budget, equip them with these tools, so when they go back out in the work world, they're able to manage their money when it comes out to that. So those are the programs that we offer. We do a lot of sessions on what is domestic violence, break it down, what is the root cause, what is the cultural norm for persons to understand. Say, a lot of the times we have found that it's constantly becomes a cycle. So child abuse is a starting point, and then no intimate partner relation. So a lot of victims, they were victim in child abuse, and now they enter into a relationship and the cycle continues. And when they check it out, their mothers would have also been in those abusive relationships. So we try to break it down for them to understand that, it's a cycle, and these are the red flags they need to look out for, and the steps you can take in ending these situations, and how to build them. And when you think about it, for survivors, I always tell them, it's not a one, it's something that constantly will come back to your mind. You will be quite okay, and then you just, think about something that triggers you. So I always tell persons, be mindful of your triggers. So you know what is a trigger. A client always said to me that standing in the bank line is a trigger for her, because she remember each time that she stand that the perpetrator will come. So she said when she see a bank line, she don't join it because that is her trigger. So she, find lines that are easy to access, and it's more safer for her. So you find a trigger and what will trigger you, and adjust as best as possible.
Okay. All right. Thank you so much. So we'll have the closing remarks starting from Her Honor, Mrs. Davis.
Having worked with the legislation, the amendments, the 2023 amendments, definitely they are a step in the right direction. But when I was at the ministry, one of the things that I suggested, and it was taken on, so I know it would be coming very soon and the Bureau would benefit from that, is that the domestic violence legislation needs a complete overhaul. Because if you look on the legislation, you will realize in neither the Principal Act nor the amendment, there is no definition of domestic violence. And that was one of the things that we pointed out for inclusion in the 2023 amendments. And then I suggested that perhaps instead of including it, we should just completely overhaul the act because of where we have reached, how technology has advanced. And so the legislation needs to be much more broad in terms of conduct that is recognizable as domestic violence. So as it is now in the legislation that we have for domestic violence is defined based on the conduct in section 4. That is what it is. And so definitely I know the government is making steps. Some things might just be moving a little slowly, but I know it is on the agenda that it is to be done. But it is a step in the right direction, and definitely it is there. The act is there to be used by men and women. Mostly it is the women that use it, but I have had a few sprinklings of men in there who have come and who have made their applications. So use the legislation. It is there for you. It is there for you, and there are mechanisms in the act that provide for you. Use them to the best of your advantage. There is something I want to mention before I hand the mic over to Dr. Rose about the maintenance that was mentioned in the presentation. As Ms. Peters said, it cannot outlast the life of the order. So what is recommended is that you make a maintenance application separate from the domestic violence. Because if the domestic violence, though the act does not mention a time limit, a maximum time limit, the orders are normally for 2 years at most. So when the 2 years run out, so will your maintenance. So just go and make your application under the Maintenance Act that will extend until the child is 18. And then when 18 is coming up, and if the child is enrolled in a tertiary institution, you go with the documents and you make that before the 18th birthday for that once you can prove, and that continues. So just bear that in mind. But definitely it's a step in the right direction, and I'm sure we'll get much further.
Thank you so much. Dr. Rose?
Again, I just want to thank you for having me here on this panel, and I want to highlight the importance of our interpersonal skills, especially our ability or inability to resolve conflicts in a peaceful manner where self is still protected and we're not harming anybody or being harmed. But that sounds like a perfect world. And as much as we live in an imperfect world, we can also choose how we engage in conflicting situations and how much of it we decide to take or not take, depending on how much value we put on ourselves. So it's important to value yourself enough to walk away from situations that do not value you. And that is so easy for me to sit here and say, and it's hard to do, which is why we are all in this room. But one of the things that's easier to do is to talk about it and to break the silence of domestic violence in the country. Let's start here in our communities first and see how much this stigma of shame and fear we can really stand up to breaking that violence based on how we also resolve conflicts. And of course, please do tap into the community networks that are available.
Thank you.
My final word would be love doesn't hurt, and there's no excuse or abuse. It doesn't matter what the situation is, there is no excuse. In Jamaica, in recent time, we're talking about jacket. It doesn't matter if it's a jacket or it's a cheating situation, there's no excuse. Reach out and get the necessary help. And as older folks, provide that support system for our young girls. Because from my standpoint from the Bureau as a social worker, a lot of the times when the younger persons comes in, the younger female, and I would reach out, what happened to your mother? Oh, she said she not get involved in a married people business, or she not get involved in a relationship. And then when you check it out, the mother herself is also in an abusive situation. Or she was before, and she said, oh, I deal with it already, so she can must pass it on. And, it's just something. Jamaican men are always beating women. It's nothing new. So teach our young folks the red flags. If you feel something about the relationship that is not good, end the situation. It's best if you walk away from the situation. Rebuild yourself when it comes down to that. I always want to say to persons, reach out to the helpline numbers. It doesn't matter what it is. You may, in a situation that you don't know if it considers domestic violence because the person is only sexually abusing or demanding sex each time and forcing themselves onto you. The female helpline numbers are 553-0387, 553-0387, 0387, and the male 553-0372. So the male 553-0372, female 553-0387, and that is it.
Thank you so very much. We are again welcoming and acknowledging the presence of persons online. So thank you for joining virtually. But we're going to now open the floor. Anybody has a question? Okay.
Ask a question. I'm addressing this question to Her Honor, Mrs. Georgette Davis. You were integral in the amendment to the Act in 2023. And was there any discussion? Well, the Act is up again for review. And there is a joint select committee that has been
convened to review the act. Pardon? Oh, you wish for me to stand? Oh, sorry about that. Yes. So the act is up again for consideration, and a joint select committee has been convened. Now, one of my concerns, I represent domestic violence victims on a weekly basis in court. And one of my concerns is that there should be some consideration for compensation to the victim/survivor of domestic violence. Speaking from a practical point of view, a lot of these women, and I'm saying women because in the last 3 years, everybody who I've represented is a woman. So my question is that, or the point is that, a lot of these women are from low socioeconomic background. All right? Not all of them are financially dependent on the person, but low socioeconomic background. These are women who are working minimum wage jobs. And these are women who miss work because they have to be going to the court, going to the doctor, whatever the case may be. So one of the orders I'm thinking that should be considered in the amendment is an order for compensation for injuries sustained and for hardship and so on and so forth under the act.
Well, I have to leave that to the lawmakers because I've now transitioned into a different role. But what I will say is that was one of the suggested amendments that we did put together when I was at the ministry. I was actually going through my laptop last night and I came up on my notes and it's right there. It was one of the things, but the decision was made to maybe address that at a joint select committee when the act is being overhauled instead of just throwing it in there as an amendment without having properly considered that particular thing, because it's going to take more than just an inclusion of that. It's going to generate a lot of discussion because now it's going to be, should we, what kind of realm are we keeping this in? You know, is it a civil? We're going to keep it in a civil. How does that work? And if it is a case that somebody has destroyed your stuff, because now the 2023 amendment, you're not supposed to damage property or so on, and or use it in a way that is so. But if someone has destroyed your stuff, there are other remedies legally that you can use. But to set your heart at ease, it was considered, and I know that as the joint select committee continues, it will come up again.
Okay, thank you.
Any other questions?
Just before I go quickly, I wanted to sort of pull in the police, members of the Jamaica Constabulary Force. They are here, and thank you very much for your service and all that you do, and thank you for taking the time to come today. Thank you very much. But I wanted to ask about the domestic violence intervention centers specifically. What exactly are these centers? What do they do? And what can we expect when we visit these centers?
Good morning, everyone. My name is Javon Brown. I'm a corporal of police attached to the Community Safety and Security Branch. I am in the Domestic Violence Intervention Unit. Now, we have 10 centers across the island. These centers were made prior to the Domestic Violence Act, 1995, I think, the Principal Act. Even from the implementation of that act, when persons went to the police station, there was scant regard for, coming and reporting any acts of domestic violence against you. Most times, police will tell you it's a man and woman something, so we're in business with it. So what the JCF did is to create a policy in terms of how police officers are to deal with domestic violence and the timeline when the reports are given, how many days we should, investigate, do the follow-ups and all of that. But the domestic violence centers were specifically made to help victims to come in and, report, just like Joni. The centers were made for victims to come in and, talk to us about the domestic violence, what is happening with you. What we do is, one, we investigate, thorough investigation is done, and then we refer, because there are some things that the police cannot do. And so we work with different stakeholders, like the Bureau of Gender Affairs, to get assistance, for the victim or the survivor. So it's really to investigate, and also we can ask the court for a protection order so we can ask for orders as well. I know the occupation order, the protection order, and the ex parte. So we can do that. So we investigate. Most times, the truth is that most times when people come to the domestic violence center, they just want help. And most times they go back to the same situation. So what we do is just to tell them what help they can get. And if it involves other offenses, most times it does. Probably offenses against a person's act, all of that. What we do is that we will investigate the domestic side, and then we will charge the perpetrator for any other offense that they, committed. So we are really there to help, but it's really more to work with the other stakeholders that we have. Criminally, we cannot charge anybody under the Domestic Violence Act. Can't charge them for an offense. So I think that we should, revisit that too. We can't charge anybody. It's just really to come and tell us what is happening with you, and we give you the necessary direction, or we help you. So that's it.
Thank you so much. Thank you so much. I'm sorry, I never know you would have come up with something like that. That's usually what between most time I was in the 80s when I got to police and still have one. So them is yes, still have one. Thank you. Go ahead.
Good morning. My question is for Her Honor Mrs. Davis. I note that under the Domestic Violence Act, there is a penalty for disobeying the protection order. But in terms of the occupation order, what maintains if somebody just goes back into a premises? Say, for example, the applicant did not make an order for a protection order, only an occupation order, then what protection does the act have in place if the perpetrator breaches that occupation order?
All right, so I'll give you the answer that you want and then backtrack a little. There is none. There is nothing under the act that speaks to, whereas, as you said, the breach of the protection order is criminalized. There is no sanction for breaching the occupation order explicitly laid out in the act, save and except if the occupation order is breached, then it would be treated as a court order that has not been obeyed. That is how it would be treated with. And you go through the hearing and this and so on. So that is what is done. I think also that is possibly something that's going to come up at the Joint Select Committee because you normally don't have, the occupation order doesn't normally come by itself. Whenever a person asks for an occupation order, it accompanies the protection order. So most times you never see an occupation order by itself. But that is definitely something that they need to look at because the act does not expressly have it there. So in my experience, I've only had one instance where someone has gone back into the house and even though they had a justification as to why, it was still a breach. So we are not necessarily handicapped, but we are not as empowered, I would say, as we are with the protection order, certainly where we have the criminal arena to deal with that if it is breached. So that is probably something that the lawmakers will be looking at in short order, I'm sure. But what we do right now, if it is breached, we just look at it as a court order that has been breached, and we use the processes to deal with that.
Thank you so much for your response. We are running out of time. We know the discussion is topical and we want to hear more. We're hoping that our guests, some of them at least, I know one has to leave shortly. I'm hoping that you will be present to answer questions, all of you. We have something special for everybody here, right? So I want to thank no, okay, you have a question? Yes.
No, I don't.
Okay.
It's only questions.
No.
Pulling your leg. Before you give your thank yous.
No, we're not there yet, but
I
go
know,
right ahead.
But
yes.
I have to run.
Yes.
But I just wanted to take the opportunity to thank and to congratulate Group K on this very important process, the extent to which they went to get this formidable panel together. And I thank you very much, Madam Parish Judge, Dr. Rose, and Ms. James, also our team from the JCF. I know that you all are very busy and that you had, I'm sure, a lot of things that you could have done other than being here. But I personally learned a lot from being here. And it speaks volumes for Group K and what they have been able to accomplish. I put on my purple, right? Domestic violence color.
Yes.
To support peace and courage. The ladies.
He will give you something purple too.
Really? And you know how hard I had to look to find I'm not a purple person. Oh, lovely. Thank you. Thank you, thank you. And thank you, Scotia. It looks like something from Scotia. Oh, I have to go to the front?
Yes, you have to. Sorry about that.
And to welcome back Miss McCallum. Okay. But just to quickly say, to thank the ladies who had the courage to come here. We really appreciate your presence. And this is a very serious issue, and I'm happy that we're treating it as such.
Thank you so much for yes. Sorry about this, ladies, but sorry. Okay, thank you so much. And did Olivia leave? Yes. She took that up. We have a gift for everybody. I will give it to her. I think in our vote, are you saying to the end? Yes? Okay, great. So we'll just give it in our vote of thanks and we'll ask and we'll ask our group members to present you. So thank you very much for the insightful discussion. We appreciate your presence, as Ms. Greenaway said, and we know that you all have benefited from this open discussion. We are going to move into the vote of thanks unless Scotiabank, you have anything to say? Yes, no? Sure. Yes.
Okay. All right. So first off, good morning, ladies and gentlemen. We are so pleased to be part of this event because we do understand the importance of empowerment. So often when persons think of Scotiabank, the first thing that comes to mind is, okay, say it a little louder for the people online. Yes, but it's about so much more than money. It's about financial empowerment of individuals. And when you are well financially, that can translate to so many other areas of your life. So when you're speaking about wellness, definitely it's about physical wellness, mental wellness, but it's also about what's happening with you financially and the different aspects of that side of your life. And so we're very happy to be a part of this, understanding the importance of the full development of the individual. And when it comes to domestic violence, it is something that impacts us as a community, not just the individual that may have been inflicted with the blows or affected emotionally. It's the entire community, from the children to the friends, other family members, in some cases where there may be alienation. So there's the breakdown of those sorts of relationships. And so it requires support of many different individuals, persons from many different sectors, financial sector, of course. And so for that reason, because it does take a village, we're happy to be on board. Congratulations to Group K, and definitely any other sorts of activities of this nature, we'll be more than happy to support.
Thank you so much. Thank you so much. All right, I now hand over to Shanari Clark. He will be giving the comprehensive vote of thanks.
Good morning, everyone. Unlike Miss Greenaway, I wasn't able to wear purple today. But with all protocols observed, it is my pleasure to give the vote of thanks for this presentation today. We have received tremendous support from the concept of this idea to its execution, all of which we are grateful for. First, the leadership of the Norman Manley Law School, the acting principal, Ms. Eulalie Greenaway, and our senior tutor, Ms. Yolanda Whiteley. We thank you for the venue and the opportunity for our students to grow and impart knowledge to these survivors about domestic violence and the act that governs same. You continue to show us that the tasks we believe are impossible can be achieved nonetheless. Today stands as a testament to the power of our determination. We also receive guidance, support, and encouragement from Mrs. Lacine Wisdom Barnett, Miss Christina Excel, for which we are extremely grateful for, Miss McLean, Miss Renee McLean. Today is as much your achievement as it is ours. Thank you for being with us along the way and giving invaluable support for the inception of this concept to its execution. Your knowledge and commitment to us was vital in aiding to make this presentation a success. Thank you for your time, effort, and of course, the late night emails and your graceful presence. We deeply appreciate you. To our esteemed and insightful panelists, Her Honor, Ms. Georgette Davis, Dr. Olivia Rose, and Ms. Joni James, who added their wealth of knowledge and expertise to make a wholesome presentation for our empowered survivors. There was an impetus to ensure that the survivors here today understand that we're all here for each and every one of you guys. And the time taken for the panelists to prepare and being present here today to share relatable stories and more information surrounding the area of domestic violence clearly demonstrates this. To our special guests, Corporal Javon Brown, Constable Moesha Brown, Ms. Carleen McCollum, Attorney at Law at the Jamaicans for Justice, and Ms. Deline Powell, Corporate Communications Manager at Scotiabank, we are eternally grateful that you found the time to join us today. And I'm pretty sure these ladies may have some questions for you after the session. To our event coordinators, Mr. Morgan and Mr. Cousins, thank you for the setup of the venue and the effective assistance with our presentation here today. To our kind and generous sponsors, thank you, a big thank you to all the sponsors. Scotiabank for funding our lunch catered by Surf and Turf, with the owner being Mr. Duran McLean. Care packages from Nestle, scented gifts from Live Simple, which was financed by Nunes, Schofield, and Delion. Finally, to the Norman Manley Law School and the Legal Aid Clinic, thank you for accommodating our desire to make this presentation here today. We appreciate you facilitating a physical and virtual space so that persons who are unable to attend still felt included in this important discussion. We thank you.
Thank you so much, Shamari. So with that, we've come to the end. We have lunch for you, but more. Oh yes, we have presentations. Could you both come to the front, Regina and Charlotte Ann? For her honor. So we got some special scented gifts from Live Simple. Yes, and they have been personalized for each of you. Thank you so much for your presence here. We have one for you too. We have one for you too. Thank. And for Carlene McCallum. One more. Yes, thank you so very much. And ladies, we have gifts for you as well. So you will have seen some blue bags around the room. They're for you. And we're going to encourage everybody here who would like a package from Nestle to take a bag. Lunch is on its way. Hoping you will be able to wait on that a little bit. He should be here shortly, but when he comes, we will deal with Mr. Surf and Turf. But it should taste good. I know that. All right, so thank you everyone for coming. Thank you, Norman Manley Law School Legal Aid Clinic. We should have, yes, Mrs. Wisdom Barnett. I know that you're very busy, but I was so touched. All the time you took my messages and you ensured that today happened. Thank you. We appreciate you very much. And for that, you get a purple bag as well. All right. Scotiabank, do you want to, while we wait on lunch? So we're finished, Mr. Cousins. Thank you too. Thank you, Garfield. Thank you for being here early. Thanks, everyone. So we're finished. Thank you all.